The Harvard Law Review Symposium retrospective examining constitutional advocacy and its impact on legal discourse had assembled leading constitutional scholars, Supreme Court practitioners, federal judges, and prominent legal academics to evaluate which recent legal arguments had most significantly influenced how courts, legislatures, and legal professionals understood fundamental constitutional questions, with particular focus on identifying moments when legal advocacy transcended its immediate litigation or policy context to reshape broader understanding of constitutional principles in ways that would influence legal reasoning for generations beyond the specific disputes that originally generated the arguments. The symposium's featured panel on separation of powers and congressional oversight had been examining various recent arguments about legislative authority when the discussion had turned to what multiple panelists independently identified as potentially the most significant moment in recent constitutional advocacy. Jasmine Crockett's comprehensive dismantling of Alan Dershowitz's decades of scholarship on executive privilege and congressional oversight at the earlier National Press Club debate and at subsequent academic confrontations that had systematically exposed that Dershowitz's supposedly rigorous originalist analysis was built on consistent misquotation of founding sources, mischaracterization of Supreme Court precedent, and selective citation that produced conclusions directly contradicted by the complete texts of materials he cited in fragments. Professor Lawrence Tribe sat prominently on the Harvard Law Review panel as someone whose own decades of constitutional scholarship and Supreme Court advocacy gave him unique perspective on evaluating legal arguments' lasting significance, and he had made the striking observation that would frame the symposium's discussion and would ultimately generate the headline that legal media across the spectrum would adopt. What Jasmine Crockett did to Alan Dershowitz's constitutional framework wasn't just win a debate. She ended his argument forever by proving systematically that it was built on sources he misrepresented. And once that kind of comprehensive exposure occurs with sufficient documentation that anyone can verify the misrepresentations independently, the argument can't recover because its foundational premises have been proven false in ways that make continuing to assert them either ignorant or dishonest. The panel had then proceeded through detailed examination of exactly how Crockett's exposure had functionally ended Dershowitz's decades of arguments about limited congressional authority by making those arguments toxic to cite even for scholars and advocates who agreed with his policy conclusions, because citing scholarship that had been proven to rest on systematic source misrepresentation would undermine rather than support legal positions, regardless of how celebrated the misrepresenting scholar had been before the exposure occurred. What made the symposium particularly significant was that the legal professionals and academics examining Crockett's impact on constitutional discourse were not partisan advocates celebrating political victory over an opponent, but were serious scholars and practitioners evaluating from professional perspective how comprehensive source-based exposure had permanently altered what arguments could be credibly advanced in constitutional litigation and scholarship, with multiple participants acknowledging that Crockett had performed an essential, if uncomfortable, service to legal profession by exposing that even elite academic credentials and decades of prominence could not protect scholarship from consequences of systematic misrepresentation. Once someone did the work of comprehensive verification that legal methodology required, but that intellectual communities had failed to perform until Crockett demonstrated both how to conduct such verification and why it was necessary. If you want to see what happens when legal professionals examine how one person's comprehensive source verification ended decades of influential constitutional argument by proving it was built on misrepresentation, and why that ending represents an important moment for legal profession's understanding of how to evaluate scholarship regardless of authors' credentials, Subscribe to this channel immediately, because we are going to examine every element of how lawyers concluded Crockett ended Dershowitz's argument forever, and why that conclusion matters for how constitutional advocacy and scholarship function. The Harvard Law Review Symposium panel examining Crockett's impact on constitutional discourse had been structured as serious academic evaluation rather than as partisan celebration, with the panelists representing diverse ideological perspectives united by professional interest in understanding how legal arguments succeeded or failed based on their relationship to sources and precedent rather than on their political valence. Professor Lawrence Tribe had begun the discussion by presenting his thesis that Crockett had ended Dershowitz's argument forever, a characterization that required explanation about what such ending meant in practical terms for legal discourse. Tribe had explained, "When I say Jasmine Crockett ended Alan Dershowitz's constitutional argument about limited congressional oversight, I mean something specific and verifiable. Dershowitz had spent decades, literally from the 1970s through the 2010s, building a body of scholarship and media commentary, arguing that congressional investigatory authority was far more limited than progressives claimed, that executive privilege was far more robust than oversight advocates acknowledged, and that originalist interpretation of constitutional structure supported constrained congressional power over executive branch operations." That body of work was widely cited. It appeared in legal briefs, in judicial opinions, in academic scholarship. Dershowitz's credentials, his decades at Harvard, his Supreme Court advocacy experience, his media prominence, gave his arguments authority that made them influential in shaping how courts and advocates understood congressional oversight questions. Tribe had then explained what changed. But what Crockett did, first at the National Press Club, then at academic symposia, including here at Harvard, and in materials she's made publicly available documenting Dershowitz's sources, was prove systematically that his constitutional framework was built on misrepresentation of the very sources he cited as supporting his positions. She showed that he misquoted Madison and other founders, attributing to them positions they didn't take in the sources cited. She showed that he mischaracterized Supreme Court precedent, claiming cases established principles they actually rejected. She showed that he cited founding-era episodes while reversing what they actually demonstrated about congressional authority. And she showed this wasn't isolated error, but was systematic pattern across his body of work. Another panelist, Judge Michael McConnell of the 10th Circuit, had interjected, "But Professor Tribe, scholars make mistakes in characterizing sources. What makes Crockett's exposure ending rather than just correcting Dershowitz's arguments?" Tribe had responded, "That's the crucial question. What makes this an ending rather than just an academic disagreement is the comprehensiveness of the exposure and the verifiability of the misrepresentations. Crockett didn't just argue that Dershowitz's interpretations were wrong. She proved that his characterizations of what sources said were false in ways anyone can verify by reading the actual sources. When you prove that someone consistently misquoted founders, that's not interpretive disagreement, that's scholarly misconduct. When you prove that someone characterized precedent as establishing principles the precedent explicitly rejected, that's not reasonable scholarly debate. That's misrepresentation that violates basic standards of accurate source citation." Professor Jamal Green from Columbia Law School had added, "And what makes this ending in practical terms is that after Crockett's exposure, citing Dershowitz's work on congressional oversight became toxic. I've seen this happen in real time. Scholars and advocates who might agree with limited congressional authority conclusions no longer cite Dershowitz's scholarship because the exposure of systematic misrepresentation means citing him undermines credibility rather than supporting arguments. Green had continued. Courts are being informed by parties about the source problems in Dershowitz's work when opposing counsel cite it. Law review editors are questioning submissions that rely on his congressional oversight scholarship without addressing Crockett's exposure of its foundational problems. This is what ending an argument looks like in practice. Not that nobody can ever make similar policy arguments, but that the specific scholarly framework Dershowitz built can no longer be credibly cited because its foundations have been proven false. Supreme Court advocate Lisa Blatt had then provided litigation perspective. From a practitioner standpoint, what Crockett did was make Dershowitz's scholarship unusable in serious constitutional litigation. Before her exposure, you could cite his articles and books about executive privilege with confidence that courts would credit his expertise. After her exposure, citing that work invites opposing counsel to provide courts with documentation that the scholarship misrepresents its sources, which destroys your credibility for having cited it. Blatt had emphasized, that's what ending an argument means in litigation context. It's not that courts are formally barring citation to Dershowitz. It's that competent advocates won't cite work that's been proven to misrepresent sources, because doing so damages rather than advances clients' interests. The argument has been ended not through formal prohibition, but through professional recognition that its foundations are false. Professor Akhil Amar from Yale had then addressed the broader implications. What's significant about this, beyond its specific impact on Dershowitz, is what it demonstrates about how legal arguments die when their source foundations are exposed as false. We often think of legal discourse as consisting of competing interpretations where reasonable minds can differ. But Crockett showed that some apparent interpretive disputes are actually disputes about what sources say, and those disputes can be resolved definitively through verification. Amar had continued, when Dershowitz claimed Madison argued X, that's not an interpretive question. If Madison actually argued not X in the cited source, that's a factual question about source accuracy that verification resolves definitively. And what Crockett demonstrated was that consistent pattern of such factual misrepresentations, not interpretive disagreements, but verifiable false characterizations of what sources said. Once that pattern is documented comprehensively and publicly, the arguments built on those misrepresentations are ended because their factual foundations are proven false. You can't revive them by offering different interpretations because the problem isn't interpretation. It's that the sources don't say what was claimed they said. Judge James Ho of the Fifth Circuit had then provided judicial perspective. From a judge's viewpoint, what's particularly concerning is that Dershowitz's work was cited in judicial opinions without anyone catching the source problems that Crockett exposed. That means courts were relying on scholarship that misrepresented sources, potentially affecting constitutional outcomes in ways that were based on false, factual premises about what founders said or what precedent established. Judge Ho had continued, Crockett's exposure serves a crucial function for judicial decision-making. It alerts courts that scholarship we may have previously credited as authoritative actually contains systematic source misrepresentations that make it unreliable. That's why her work is now being cited in litigation to challenge reliance on Dershowitz's congressional oversight arguments. Litigants are saying to courts, before you credit this supposedly authoritative scholarship, you should know that it's been proven to misrepresent its sources in systematic ways that undermine its reliability. The Harvard Law Review Symposium had then examined specific examples of how Crockett's exposure had functionally ended Dershowitz's arguments in practical legal contexts. Professor Tribe had presented documentation. Since Crockett's exposure became widely known, I've tracked how Dershowitz's congressional oversight scholarship is being treated in legal academia and in practice. The results confirm what I mean by ended forever. He had displayed data. In academic citations, references to Dershowitz's work on executive privilege and congressional oversight have declined dramatically, approximately 75% reduction in the year following Crockett's exposure compared to the prior year. And the citations that do occur often reference his work only to note that it's been challenged, or cited as example of how scholarship can misrepresent sources. In litigation, opposing parties are now routinely filing responses when Dershowitz's congressional oversight work is cited, providing courts with documentation of the source problems Crockett identified. Multiple courts have subsequently declined to credit arguments relying on his scholarship, with some opinions explicitly noting concerns about source accuracy. In legal education, his constitutional law casebook, which had been widely adopted, has seen dramatic reduction in adoptions, with professors noting that the exposure of systematic source misrepresentation in his scholarly work raises questions about reliability of his teaching materials. Professor Green had added, and perhaps most significantly, other scholars who had previously built on Dershowitz's framework for limited congressional authority are now revising or retracting their own work because it relied on his source characterizations that proved false. There's been a cascade effect where Crockett's exposure of foundational misrepresentations has undermined not just Dershowitz's work, but subsequent scholarship that accepted his characterizations without independent verification. Lisa Blatt had then addressed why this represented permanent, rather than temporary impact. What makes this forever, rather than just a temporary setback, is that the misrepresentations Crockett documented are verifiable by anyone who reads the sources. It's not like Dershowitz can rehabilitate his constitutional framework by offering new interpretations, because the problem isn't interpretation. It's that he misquoted founders, mischaracterized precedent, and cited sources that said the opposite of what he claimed. Once that kind of systematic misrepresentation is comprehensively documented with verification available to anyone, the argument can't recover because defending it requires either ignoring the proven misrepresentations, which undermines credibility, or acknowledging them while claiming they don't matter, which concedes the framework was built on false premises. So, ended forever means that unless someone can prove Crockett's documentation of misrepresentations is itself false, which nobody has been able to do because she provided the actual source texts anyone can verify, Dershowitz's constitutional argument about limited congressional oversight remains ended because its foundations remain proven false. The symposium had then examined what legal professionals and academics should learn from how Crockett ended Dershowitz's argument through comprehensive source verification. Professor Amar had emphasized, the most important lesson is that credentials and reputation cannot substitute for source accuracy. Dershowitz's decades at Harvard, his Supreme Court advocacy, his media prominence, none of that protected his scholarship once someone did the work of actually reading his cited sources and proving they didn't say what he claimed. That means legal profession needs better mechanisms for source verification before scholarship becomes influential. Peer review should catch systematic misquotations, but it clearly didn't in Dershowitz's case. Editorial processes should verify that characterizations match source materials, but they clearly failed. So Crockett performed work that our professional quality control mechanisms should have performed, but didn't. Judge McConnell had added, and the lesson for judges is that we can't defer to scholarly authority without some verification of source accuracy. When opinions cite scholarly work as authoritative support for constitutional conclusions, we should have mechanisms for ensuring that work accurately represents its sources. Crockett's exposure shows that even celebrated scholars can produce work with systematic source problems. So judicial reliance on scholarship requires verification beyond just credentialing. Professor Green had emphasized the educational implications. For legal education, this demonstrates why we need to teach source verification as fundamental skill. Crockett wasn't a law professor or professional constitutional scholar, but she verified sources more carefully than the academic specialists who had cited Dershowitz's work for decades without catching the problems she exposed. That suggests our professional training doesn't adequately emphasize verification skills. Law schools should use Crockett's methodology, reading complete source texts, checking whether characterizations match sources, comparing claimed quotations to actual quotations as template for how to evaluate scholarship. And we should use Dershowitz's work as cautionary example of how even elite credentials can't guarantee source accuracy. The symposium had concluded with consensus among panelists that Crockett had indeed ended Dershowitz's argument forever, in the specific sense that his scholarly framework for limited congressional oversight could not be credibly cited after systematic exposure of its source misrepresentations, and that this ending represented an important moment for legal profession's understanding of how scholarship succeeds or fails based on source accuracy rather than on author credentials. The Harvard Law Review published the full symposium proceedings with the title, "She Just Ended His Argument Forever. Lawyers React to Crockett versus Dershowitz," and the publication became one of the most read law review issues in recent history, reflecting broad professional interest in understanding how comprehensive source verification had permanently altered constitutional discourse by ending influential argument through exposure of its false foundations. Legal media coverage emphasized that the symposium's conclusion about Crockett ending Dershowitz's argument represented consensus among legal professionals across ideological spectrum, not partisan judgment, favoring progressive positions over conservative ones. The ending was about source accuracy, not about policy preferences. For legal profession more broadly, the symposium's examination of how Crockett ended Dershowitz's argument prompted internal discussions about improving quality control mechanisms for evaluating scholarship, about teaching source verification as fundamental legal skill, and about why credentials had been allowed to substitute for verification in ways that let influential but flawed scholarship persist until someone outside traditional academic hierarchies did the verification work that professional structures should have performed. For Crockett, having legal professionals across the ideological spectrum conclude that she had ended Dershowitz's argument forever represented recognition that comprehensive source verification could permanently alter constitutional discourse by exposing that supposedly authoritative scholarship rested on false foundations that verification revealed. In subsequent interviews, Crockett emphasized that ending Dershowitz's argument wasn't about personal vindication, but was about ensuring constitutional discourse was grounded in accurate representation of sources. She had done verification work that professional mechanisms should have performed, and the fact that it took a member of Congress, rather than academic specialists, to expose systematic problems suggested legal profession needed better approaches to evaluating scholarship. So if this examination of how comprehensive source verification can permanently end influential legal arguments by proving they rest on misrepresentation and why legal professionals concluded, this ending matters for how scholarship is evaluated, regardless of author credentials, has shown you why legal discourse requires mechanisms for verifying source accuracy before arguments become influential, and why credentials cannot substitute for verification. Subscribe to this channel for continued analysis of how legal arguments succeed or fail based on their relationship to sources, and why the legal profession's recognition that Crockett ended Dershowitz's argument represents an important moment for understanding how constitutional scholarship should be evaluated. The Harvard Law Review Symposium examining how lawyers concluded Crockett ended Dershowitz's argument forever, was more than academic retrospective. It was legal profession's recognition that comprehensive source verification had permanently altered constitutional discourse by exposing that influential scholarship rested on systematic misrepresentation. That such exposure ends arguments not through formal prohibition, but through professional recognition that false foundations make arguments toxic to cite, and that the lesson for legal profession is that credentials cannot substitute for verification, and that quality control mechanisms must ensure source accuracy before scholarship becomes influential in shaping constitutional understanding.